The constitutional law fact pattern from July of 1995 is about as straightforward as a con law question can be. But you wouldn't know it from the call of the question. Have a look at it. It reads, how should the court rule on issues raised by board's motion? Discuss. Well, this could be a civil procedure question for all we know, based on the call of the question. Let's review the fact pattern, and we'll see the examiners basically spoon-feed the issues to us. So our job is going to be give it back to them with plenty of value added. Take a look at the very first paragraph. Teenage pregnancies have increased the number of school dropouts, so the Board of Education of City, the group making the motion, adopted an alternative education program, AEP, for unmarried students under age 18 who become pregnant. All such students must participate. AEP offers a special core educational curriculum supplemented by counseling and instruction on prenatal care and other issues facing unwed teenage mothers. Once placed in the AEP, the student remains throughout the term of her pregnancy and until the end of the school year in which her pregnancy terminates. Well, we can stop right there and ask one question that might come very quickly to mind. What about boys? These girls are not getting pregnant by themselves, and it looks as if this program doesn't do anything with regard to the young men who are involved in these teenage pregnancies. So it looks as if, on its face, we've got a problem with equal protection and a discrimination based on gender. We know that gender discrimination is adjudicated based on the intermediate standard. Now in paragraph 2, we meet Pam. She is unmarried, 16, an 11th grader at City High. She's pregnant. She wants to stay in her regular classes at City High, but she's been sent to the AEP. Now, read carefully. She has sued the board in federal district court for declaratory and injunctive relief, seeking a return to her original classes. Pam's complaint alleges that being assigned to AEP violates her right to equal protection of the law guaranteed by the U.S. Constitution. And you know what? I think she's right about that. It looks like a discrimination based on gender. Read on. It penalizes her for exercising a fundamental right protected by the substantive due process provision of the Constitution, presumably dealing with privacy and the issues surrounding pregnancy and childbirth. She may have a pretty good point there too, huh? Now we read about the final facts in the third paragraph. Shortly after Pam's suit was filed, the school year ended, and during the summer, she suffered a miscarriage. The board has transferred Pam back to the regular high school classes and has moved to dismiss her complaint on the grounds that, 1, the action is moot, and 2, the complaint fails to state a claim for relief under the Constitution. And then we get the call of the question. How should the court rule on the issues raised by the board's motion? Discuss. Well, they give us the issues. We need to organize them effectively and then carefully and meticulously analyze the facts. So the first allegation that we are facing is that Pam's action is moot. So please take a look with me at the outline of issues, and you'll see that I begin with standing and ripeness. Then I focus on mootness, and my conclusion, mootness is not going to be grounds for dismissing this action. We'll take a look at my analysis in greater depth, and I'll show you a few more details. Secondly, we're asked that the board alleges that Pam's complaint fails to state a constitutional law claim. Well, fortunately, we are given her 2 claims, and we can examine each of them separately. First, equal protection. Notice I indicate gender discrimination and intermediate scrutiny. Then I use in a heading the standard of review. Is the board's action substantially related to an important government interest? But then notice also I've suggested a second equal protection claim that Pam could bring, and that's based on age discrimination. And age is mentioned in the statute, so we need to find a home for that in our analysis. The age discrimination claim will be judged on a rational basis standard. I conclude, with regard to equal protection, that Pam's claim should not be dismissed. Next, we turn to her substantive due process claim. I focus on privacy. I apply the strict scrutiny standard. and I conclude that the motion to dismiss Pam's substantive due process claim also should be denied. Also, well, I said this was going to be a straightforward fact pattern, and it is. It's also a short fact pattern, which means we have to be especially meticulous with regard to the facts. So now let's take a brief look at my answer, and I'll show you a few paragraphs that I think might be worth a little bit of attention. Notice in the very first paragraph I write, I lead with the facts. I indicate the procedural basis of the suit. Pam has filed suit for declaratory and injunctive relief, and I indicate that the court is ruling on motions to dismiss. I start out with ripeness and mootness, and I focus on the fact that this plaintiff, Pam, has an injury in fact based on the actions taken by the board. Pam has standing. Also, the case is ripe for review because questions of law about the constitutionality of the AEP have been raised, and the record is completely ready for adjudication. Next, we focus on mootness, which really is the core of this call of the question. And here, I indicate 3 facts that the board relies on to support its motion to dismiss Pam's case. There's been a miscarriage, the school year has ended, and Pam is back in her regular classes just as she wished to be. But this is a rather problematic argument. And the problem is, although the immediate cause of Pam's exclusion from her regular classes is over with, similarly situated teenagers, including Pam, might be subject to the AEP in the future. And since we've got a 16-year-old and the law goes up until 18, I think it's pretty obvious that this litigation should be allowed to proceed because Pam's problems are likely to be repeated, either by Pam or by someone like her. This is a complaint that should not be dismissed on mootness grounds. So now we get into the real core of the analysis. We already know that ripeness, standing, mootness, all of these preliminary issues often are in play in con law essays, but rarely are they the heart of the question. In fact, they're rarely mentioned in the call of the question. So to some extent, this question already is a little novel in that regard. But now we get to the real core of the question, and the part that this question has in common with so many other con law questions over the years, the con law theories. So let's have a look at them. First, the board is alleging overall that Pam has failed to state a claim for relief under con law. Well, that's fair enough. Let's have a look at them. If you look at the first paragraph under Roman numeral 2, I set up the analysis with a couple of quick sentences, and then we move to equal protection. Notice that I lead off here with a small amount of law indicating that the Equal Protection Clause of the 14th Amendment applies to the states and to the federal government via the 5th Amendment. It prevents them from discriminating against protected groups, and there are different standards of review based on the group that is alleging discrimination. So we focus on the gender discrimination claim, and we apply the intermediate basis standard. Have a look at the 2 paragraphs that I write under gender discrimination, and here I think you'll see that I am both comprehensive with regard to the facts, and I am clear about what the law is, and I set the framework for our subsequent analysis with the constitutional standard. Is the discrimination substantially related to an important government interest? I follow that up with 2 paragraphs on this issue, connecting the facts and the pattern with this gender discrimination equal protection standard. In the end, I conclude that this is almost certainly going to be a violation of equal protection. I also work in a discussion of age discrimination. I do that in maybe 3 short sentences. But the bottom line here is Pam has stated a valid constitutional claim based on equal protection, and it would be wrong for the court to dismiss her action based on a finding that there was no constitutional claim stated. The equal protection claim is valid. It should be litigated. Next, we turn to substantive due process, and here again, I give a little bit of law to set the stage for the analysis, and I explain that government is prevented from interfering with people's fundamental rights unless the interference can satisfy the strict scrutiny test. And I state the standard. The government has to show that the interference is necessary to achieve a compelling government interest, and no less restrictive means are available. Now, if you catch me reciting law like this in an answer, you are well advised that you should have it memorized. I don't recite the law like this lightly, and I don't do it very often. But here I really do think it's necessary. We have to recite the applicable constitutional standards. But you'll notice I'm not doing it in a vacuum. I'm doing it in the context of factual analysis that's responsive to the question presented. We're not going to get points for boilerplate, but we do need to make it clear to the examiners that we know the law, and particularly we know how to apply the law to the facts in a given question. So we focus on privacy as a fundamental right, and this gives Pam a real stake in a substantive due process claim. Next, we turn to strict scrutiny, and it's clear that the board is not going to be able to satisfy the strict scrutiny standard. Perhaps they could meet intermediate scrutiny, although I have my doubts about their success even there. But the bottom line here, again, being responsive to the call of the question, is that Pam has stated a valid constitutional claim based on substantive due process, and the board shouldn't be able to get her lawsuit dismissed for failure to state a claim. And that wraps up a discussion of a straightforward, but not terribly easy, constitutional law fact pattern. Once again, we get a chance to focus our attention on constitutional theories and applying them to fairly specific and somewhat complicated facts.